I'm Stephen Thrasher, staff writer for The Village Voice, and I'm talking to Chris Geidner of Metro Weekly. Hello, Chris.
Hi, Stephen.
So the Gill decision comes out today. Give us a
Yes.
little overview of it and why this should or should not be extremely exciting news.
This is extremely exciting news, I'd say. It is the first time that a federal appeals court has ruled that Section 3 of DOMA, which is the federal definition of marriage and spouse, is unconstitutional. And not only was it a unanimous decision of the First Circuit panel,
Which is a
but
three-judge panel.
it was a three-judge panel that included two Republican appointees and one Democratic appointee. And the decision was written by Judge Booten, who is a conservative Republican appointee. So it is everything that GLAAD, the Gay and Lesbian Advocates and Defenders who brought the case, wanted out of this decision.
Was there anything that they didn't get?
I mean, there are things that perhaps an ideal decision for, say, the best gay decision you could get didn't happen, but the best gay decision you could get wasn't necessarily the best decision for striking down DOMA. The decision, I mean, there's always this question that's been before the courts hearing these cases about what level of scrutiny should apply to classifications based on sexual orientation. Whether it should be this strict scrutiny that's afforded to classifications based on race, some intermediate scrutiny like sex-based classifications get, or whether or not the rational basis, which is the lowest form of scrutiny that applies to sort of any governmental classification, whether that should apply. And there are arguments made by the Department of Justice and others that heightened scrutiny should apply to sexual orientation classifications, one of those two higher scrutiny levels. But the court today held that it wasn't the court to decide that heightened scrutiny should apply. That there was an earlier First Circuit case, Cook, that related to a don't ask, don't tell challenge, that the court held sort of binds it to rational basis, but then Judge Booten went on to say that the Supreme Court had also not decided that a level of heightened scrutiny should apply, and basically said they had some opportunities to do so and they didn't, so we're going to leave it to them to do that. We're not going to be the court to make that decision. And I think that is not unreasonable, and it's also the sort of deference that a court of appeals will give to the Supreme Court on these sort of big issues.
Mm-hmm. So as I understood it, not being a lawyer, they did not ask for a stay at this level, assuming a level of review will happen above them?
They did put in.
Oh, they did, okay.
They said it didn't matter if a stay was asked for or not. They said that they are putting the case on hold until further resolution. They actually said that Supreme Court review of DOMA is highly likely, and so therefore they stayed the decision.
I guess they have a crystal ball. Who is Gill, and in the short 30-second version, what was Gill asking for?
Nancy Gill and Mary Letourneau are the two lead plaintiffs in the case that GLAAD brought. And they are one of, I believe, 8 couples, and Dean Hara, the widow of Representative Jerry Studs, are the plaintiffs in the challenge, and they are arguing a number of things, basically going through federal law. And I mean, we've heard about it for 15 years now, the 1100 benefits of marriage that are conferred by the federal government, and they found some of them, basically, that various people of these plaintiffs have been impacted by, from Social Security benefits to federal employee health benefits, FEHB programs, to, in the case of Dean Harris, survivor benefits. And
Did they deal with immigration or anything along those lines, or not in this case?
no, none of the GLAD cases have dealt specifically with the immigration question.
So, how important do you find this case to be amongst the various competing cases that are making their way through the federal judiciary right now, including the Prop 8 case in California?
Right now, this is the most important because it's the one that is moving forward. Um, by default, it becomes the most important today.
What about also, though, thinking in terms of the implications that any of these cases could have? Is this something that stands to be a very limited case in terms of Massachusetts, or does it stand to potentially
No,
have a broad variety of, you know?
this has nothing to do with Massachusetts. I mean, the only thing that this has to do with Massachusetts is that this is not a marriage equality case, and that, I mean, that's the, I mean, comparing this to the Perry case is a little unfair, because this is not, no, the Supreme Court could say this opinion is completely correct, we agree, and the next day, not a single new same-sex couple would be allowed to get married. All that this opinion does is says that for those states that have decided to end marriage discrimination, as Evan Wolfson would say, in those states, the federal government cannot pick and choose amongst the married couples and say we're going to treat these married couples, opposite sex married couples, one way, and these married couples, same sex married couples, a different way. That there is no, and as the three judge panel agreed today, there is no rational basis for doing so. And all that is as Mary Bonato, who's the lawyer from GLAD who argued the case, said, this is a classic equal protection challenge. This isn't about creating new rights. This isn't about expanding the scope or reach of anything. This is about looking at a law that's treating two groups of people differently, and there's no good reason for doing so.
And speaking of the lawyers involved, I see that Paul Clement was arguing this case as well. It doesn't seem like there's any high-profile case for the conservative side lately that Paul Clement has not been arguing.
Well, yeah, I mean, this was one of the cases that I wrote about recently in the Daily Beast, that Paul Clement has sort of been on all sides of the federalism debate this year, arguing in the Arizona SB 70 immigration case that the state government should have the right to implement a traditional federal area immigration law how it wishes to do so. That in the healthcare case, the Affordable Care Act case, arguing that the federal government didn't have the right to engage in this sort of legislation, and then arguing in the DOMA case that in an area of traditional state recognition and state authority, that the federal government did have the authority to intercede and pass DOMA. So he's sort of been on all sides this year, and obviously a lawyer has the responsibility to argue positions for his clients. But I think that the DOMA one from a is there any coherent ideological position behind Paul Clement's arguments? The DOMA case sort of throws that out.
Well, maybe the Alice in Wonderland incoherence of the Obama position, now that that's been clarified, has now been sucked into the other side a little bit. um, so, is it fair to say, I was trying to talk through some hypotheticals around this with someone earlier today. So, is it such that should the Supreme Court uphold this decision, that same-sex partners could legally marry and be able to say whatever existing federal rights there are, they should be able to engage in? They should be able to file their taxes, or if they're a federal employee, be able to have their benefits go to each other. Correct?
Yeah.
But what about a more complicated, say you live in a state where you are allowed to marry a same-sex partner who's not from that jurisdiction. You marry someone from a foreign jurisdiction, and the state allows that marriage to be legal. Then would you, under this ruling, hypothetically be able to petition the federal government for immigration status for that person? Or would we then be saying that's a new form of law that has not yet been answered and probably wouldn't be covered by such circumstances?
Um, well,
And if you don't know, that's fine.
well,
I'm
no,
sure
I
we'll
mean
be arguing about this
it's
for
well,
years and
and
years to
that's
come.
the
And
line is that I mean there are 20 different answers to that question, and those are all things that the Department of Justice, that the Department of Homeland Security, that the Obama administration, that Congress, and that the courts are going to have to resolve. This is this decision that the when DOMA Section 3 is no longer law, as Elizabeth Birch, who was running the human rights campaign at the time, always says, we'll then be back to 1996. We then need to figure out how we deal with things, because if there's actually there's a case in the Ninth Circuit, Adams versus Howerton. I think I got that right. That had been decided before DOMA, that its ongoing legitimacy is questioned, and certainly immigration lawyers fighting for binational couples think it's bad law now. But that even before DOMA had decided that same-sex couples didn't have the ability to sponsor their partner for immigration purposes. And so there's just eliminating DOMA itself doesn't resolve all of the questions, because there was law already going into place or established before DOMA, and there's other law that's just ambiguous, and that would have to be at least clarified, that the answer might be obvious. I mean, I think it's obvious to most people that if you eliminate DOMA Section 3, that same-sex married couples would be able to be established for green card purposes. But then there's the question of, what about in, say, New Jersey or California currently, or another, or Illinois, where they have a civil union or domestic partnership? Is that sufficient? And these questions are going to remain even after DOMA's gone.
so, two last things. One, given your superhero-like abilities of predicting the future, what do you think is a realistic timeline the Supreme Court will hear the case, or even just say whether or not they're going to hear the case?
Well, the decision by BLAG whether or not they're going to appeal seek what's called a petition, a writ of certiorari from the Supreme Court, is going to be They have 90 days. So we're talking about the end of August. And that will start a briefing period that they will file a brief saying, Supreme Court, you should accept this. Then the GLAD and DOJ and Massachusetts will file briefs saying whether or not they think the Supreme Court should accept it. And then the Supreme Court holds a conference where the justices sit around and decide, and you need 4 justices to say that they want to hear a case in order for the court to accept it. And then if the court accepts it, then then they would that sets up another timeline for what's called a merits stage briefing, and that's when they argue DOMA itself, and that's when you have, I mean, in this sort of a case, you'll have what amicus brief, which is friends of the court briefs, and they'll be filed at both the cert stage and at the merits stage. From outside groups urging the court what to do.
And could all that happen in the next term?
It most likely would happen. This would be a decision. I mean, if the Supreme Court gets this around November, they would most likely, the way that the court's been going in recent years, they would most likely be accepting it for later in that same term. So, I mean, you're talking about oral arguments in
2013.
In early in the first half, which would mean that you would expect a decision. If that happens, then you would expect a decision by the end of June, before the 4th of July of 2013.
And last question, how differently will that process that you just described happen under an Obama administration or Romney administration, also in terms of BLAG and whether or not which administration's DOJ would continue pursuing things or not?
Right. Well, you would have you could have a very, very, very strange situation, because you could have the cert petition filed by the Obama DOJ in, say, October, and then if the court accepts the case and in November Romney wins, depending on the timeline set, you could have either a very awkward situation with the Obama administration rushing the brief out the door before January 20th, or I would imagine more likely at that point, because the oral arguments would be by the next administration, a request to delay the case until or at least the briefing, until the new administration comes in. And at that point, then you would have based on what Governor Romney has said thus far, would be a brief defending DOMA, which then might result in either BLAG moving back to an amicus role or continuing to be a party. It's
also,
you've created a definite piece I'm going to need to be writing over the next.
Yeah, and well, then just to inject more chaos into it, if you have a Democratic House, if you have a Democratic president, and a Democratic, perhaps Nancy Pelosi would not have BLAG continue fighting?
If I guess that's the direction in the opposite, the decision in the opposite direction. If Obama wins re-election and the House is taken over by Democrats, is that what you mean?
Yeah.
Because I don't think you're going to see a situation where Romney wins and the Democrats take back the House. So I don't think you'd see that flip. But yeah, I mean, you could have a situation where Paul Clement gets fired. And that is a third article to be written. So thank you. I now don't get to sleep because of you.
All right. Thank you very much, Chris.
Thanks, Stephen.
Have a good weekend.
You too.